Before we proceed with the day's sessions, we would like to honor the life of Mr. Goddaer, a visionary who was with us from the very beginning when GIPC first took roots in the vibrant city of Kolkata in 2009. Mr. Iyer's deep passion for law, technology, and innovation has left an indelible mark on all of us. His tireless dedication, sharp intellect, and commitment to mentoring countless individuals are part of the foundation on which GIPC stands today. We are forever grateful for his contributions and the legacy he leaves behind. Thank you, Mr. Iyer. As we move forward with today's session, I'd like to highlight the QR code at the back of your badge. Simply scan it to access the GIPC 2025 networking portal using your registered email ID and OTP. The portal allows you to chat, schedule meetings with fellow attendees, and view the agenda and speaker details. Please use it as much as possible through the excitement of the 2 days to follow. A quick note about the bag tags in your delegate bags. Please feel free to use the pen provided to you to write your names on the bag. Now that we have explored the events portal, I'd like to mention that all the sessions today will follow a uniform format. Firstly, we will begin with the moderator's opening, a warm welcome and a 3-minute overview followed by panelist statements, where each panelist will get to share their perspectives in the span of 3 minutes, totaling 15 minutes. Next is the guided session with 3 to 4 structured questions ensuring diverse insights over 15 minutes, followed by a 5-minute audience Q&A. Finally, the session wraps up with closing remarks in 2 minutes. With 10 minutes of grace time built in, we are excited to dive deep into an engaging and thought-provoking discussion. Now, please put your hands together for us to welcome the first plenary session of the day, IPR governance and policy implications in AI. This session, we would be exploring AI's evolving role in patentability, its use in creating inventions, and protection for AI-driven manufacturing outputs. It will be moderated by the esteemed Professor Dr. Heinz Goddaer from Munich. I'd like to request Dr. Goddaer to please come up on stage. He's a distinguished patent attorney, IP professor, and global authority in intellectual property. He's a recipient of the prestigious IAM IP Hall of Fame induction and the LESI Gold Medal. Welcome, Professor Dr. Heinz Goddaer. Joining him will be our first speaker, Mr. Hari Subramaniam, founder of Subramaniam and Associates. With over 40 years of experience, Mr. Subramaniam has handled over 45,000 patent matters and initiated mailbox applications in India. As president-elect of the APAA, he has made significant contributions to legal education and pro bono work. Welcome, Mr. Subramaniam. Secondly, we have Dr. Mohan Diwan of RK Diwan and Company. With 45 years in IP, he is a patent and trademark attorney specializing in trademark law, patent drafting, IP commercialization, and litigation. A sought-after speaker and trainer, he is widely regarded as a leading IP lawyer. Welcome, Dr. Diwan. Next, we have Dr. Prabuddha Ganguly. He is the CEO of Vision IPR. Dr. Ganguly, an IPR expert, advises WIPO and serves as an honorary professor at HBNI. His numerous accolades, including a Lifetime Achievement Award for his contributions to IPR. Welcome, Dr. Ganguly. And lastly, for this session, we have joining us Dr. Anju Khanna, Head of Patent Department at Lal and Sethi. With over 21 years of experience, 17 of them being in the patent department, she is actively engaged in policy making with DPIIT and CII. Welcome, Dr. Khanna. With that, I'd like to request the audience to please help us commence this session with a huge round of applause. Over to our panelists. Thank you.
Yeah, thank you so much. First of all, thanks a lot to the organizers again that I have the pleasure and honor to be the moderator in this first session. Secondly, to thank the panelists to be so patient as to not be my victims, not at all, but the main contributors to what we present to the audience now here. And I would like to follow the instructions, the very clear and strict ones, which we got how to run such a round table as much as possible. So I wish to be brief. And I wish to tell you two things. First of all, where I personally think at the moment the problems and challenges and chances in the relation between IP, particularly patents, maybe also trade secrets, maybe copyright questions, and the ever-increasing role of artificial intelligence is. I have seen, and I don't wish to anticipate anything, what, however, is all over the world going on, upcoming regulations, what you can do with IE, what you are allowed to do in the public interest, in the interest of society, and in the interest of creators of AI connected technologies, let's say. Secondly, where the future developments probably will go. I will take another 1.5 minutes, I think, for the rest of what I would like to take, not to talk about specific aspects we have in Europe at the moment. So one thing is patentability, eligibility of AI inventions settled from my perspective worldwide. Second, can AI be an inventor or not? Settled except in 2 countries of this world. I think it is South Africa and Australia completely, and I don't wish to comment here. The last point is, what do we do with products made by generative AI or assisted by that? How should we continue with that? What could we learn? What needs still to be done by legislation, by case law, by court practice, by practitioners? That's it. And I would like now to invite, without taking now a long time to tell you more about what is happening in Europe, and Germany is a part of Europe, and I would focus on what is going on there. But I would like to take this general introduction only. Now, who, in which order to speak? I think we have one very simple question at the moment here to solve. Ladies first, of course. So I would say, do you see the current problems in about 3 minutes? We were instructed. I have only repeated what I see otherwise coming to us, 241. You talk about where you see the biggest problems, the chances, etc. Then we go a little bit according to seniority. The person next to me, I will do this and we'll talk about that. Then comes another academic colleague, highly esteemed by me. It is my dear friend Prabhu, who was one of my scouts into the Indian world of intellectual property. And last but not least, we have been on so many panels together, and each of you should, we know each other, but should briefly explain to the audience who you are, what you are doing, but not taking more than 3 minutes for that. Better only 1 minute and 2 minutes for the factual things we are allowed. And later on, the questions we will talk about, I can tell you already now. I wrote to you, I think, at least to some of you. The biggest question I see is at the moment, don't we need to revisit the problem? You don't at the moment probably not see where I am aiming, but do we have to visit this question again? If something like a research tool in pharma research, like AI in creating something out of something else, do we need to revisit the scope of protection of patents? That means products made with the help of such a thing, should they not be protected also by already a method which includes the application of the AI? That's it. That's later on our discussion. The audience, I say this now, they can already start thinking about this so that we have some food for thought given to our audience. And now it is up to you. You start.
Thank you, Professor Goddaer, and thank you for giving me the first opportunity here. And that's always the advantage, at least one advantage I have as a woman, you know. So, and I would also like to thank GIPC for giving this opportunity for speaking in such an esteemed panel. Well, there are several problems, actually. AI and IP, I just would not say there's just one problem. And so there are two aspects to this, according to what our topic is today. One is, of course, the IP vis-a-vis AI, and the other is the governance and policy vis-a-vis AI. So the first thing about IP is that how do we protect AI or AI-related inventions? So you have patents, you have trade secrets, you have copyright. Now, patent, of course, we are facing a lot of problems in patenting. From the India perspective, I would say that we have this subject matter eligibility, and throughout the world also, not just in India, but Section 3K is a big hindrance. And we have the sufficiency of disclosure requirements, we have the enablement requirement, and besides the other regular patentability requirements. So that is vis-a-vis patents is a big challenge. The speed of the invention is so fast in AI that sometimes when patenting doesn't seem to be the right process, because the process itself, even the quickest you will get a patent would be at least 2 years. You know, so is trade secret a better option? You know, so trade secret, of course, has its own drawbacks. So for example, in India, we still don't have sui generis law in India for trade secrets, and also there is no registration process for trade secrets. So that's another aspect, and of course, there's copyright, which I'm not an expert at, but yeah, we can discuss the copyright aspect also. Then there is the aspect of sui generis AI regulation, which I think the government of India in the parliament has said very clearly that we are not going to opt for that. We are not, the current laws are very much, you know, adequate to take care of whatever problems may arise of AI. Though, in my personal opinion, I think right now we are very scattered. At least the government of India appears to be very scattered as far as regulation in AI is concerned. And again, that is the same problem that we are facing about patenting software, for example, 20 years ago, that we don't want to stop you know, innovation. We don't want to hinder innovation. So, I mean, what comes first, the chick or the egg? That's a question we need to answer for AI, but I think AI is a very different ballgame, so we really need to think very hard about regulation in AI. So these are the two aspects I think we need to discuss today. That is my take on it. Thank you.
Thank you so much. And for two things, for the content, really food for thought again. Second, also for keeping your time. Thank you so much.
Well, I've been involved in several AI-related inventions in the last God knows how many decades, probably 20 years. The biggest problem that I face is I don't understand a word of any of those inventions. You know, and I'm sure that's the way it is for most lawyers, patent examiners, litigators, and the judges as well. We are talking about AI as if it's something that's new today. AI is not new. It's always been there for ages. But what is new is we are talking about AI in terms of protection and enforcement and ownership. I recall ages ago, 1986, you know, I'm a chess player, and I was an arbiter in a inter-computer chess championship in the Manhattan Chess Club. And computers were playing against each other. And it was amazing how computers played against each other, and in speed and with a depth of calculation defining human imagination. And then a grandmaster played against the winning champion computer, which was called Deep Blue, and actually defeated the computer. And at that time, the chief guest at the championship said, I don't think computers can ever beat a human being. But I think that day is gone today. Today we are talking about AI created by human beings, and the AI created by the human being can beat the human being who created it in a blink of an eyelid. The possibilities that an AI can do today is enormous. It's defying, it's thought defying. But that is not our problem. Our problem is how to protect what AI creates, and who deserves those protection, and who is competent to actually protect them. A lot of things have been talked about, whether AI can be an inventor, or if I can be named as an inventor, if the AI created by me invents something. There's a famous case of Thaler versus Controller Patent in UK, where Dr. Thaler wanted to be the patent applicant because the AI belonged to Dr. Thaler, but did not name AI as an inventor because UK Patent Office was very clear that the AI is not a human, therefore it can't be an inventor. And the patent application was refused because it was the first time a patent application was filed without an inventor being named, because there's no inventor, yet there is a creation. And that patent application got rejected practically everywhere in the world except South Africa, because South Africa is one of the few countries where the examination of patent happens when it's enforced, not when it's granted, when the patent is granted. So that's one of the cases. Yet there was another case in UK, Anderson versus Stability AI, where a consortium of 3 artists sued an AI for copying various images and creating an image. So there was one case, that was while it involved the issues of copyright, their AI was a defendant. So if AI is a defendant, can AI be a plaintiff? If AI be a plaintiff, then can AI be an inventor? That opens up Pandora box again. And finally, let's assume that AI created inventions are patentable, or AI can be created, can be named as an inventor or as an applicant. Who is really competent to examine patent applications of AI? Can an ordinary examiner be an examiner of AI-created invention? Can a person skilled in the art be competent to depose on the inventive step of an AI-created invention, or do you require an AI as an examiner itself? In that case, you would also require AI as a judge. So these are, the problems that we can think about as lawyers, which is our job. It's endless. And sometimes we can create issues before the courts, before the policymakers, and between ourselves, for which we have no answer. And we've been looking for answers. I'm sure we'll be looking for answers 20 years ago. From Indian perspective, it's pretty easy, because we have provisions, we have special statutory provisions which make many inventions unpatentable. And as of today, a lot of AI-related inventions may not be patentable, but at the same time, if AI, the computer program of software is not the pith and marrow of the invention, probably it could be patentable, but then you have to have a human inventor and a human applicant. So with this, I'll hand it over and go to the next speaker. Thank you.
First of all, cordial thanks. Now I am asking, I think, yeah, okay, then you will be last, Prabhu. Okay, thank you. I think you have a microphone yourself, then if it works, otherwise I share mine or I give you mine. Maybe that works. Normally in India these devices work. I know countries where it is much more difficult. Okay, no technical background. Yeah, a chemist, okay.
Yes, it works. It works. My journey in the field of patents has been for the last now 52 years. On both sides. I've been an inventor. I have 52 patents granted in my name. And my first AI patent application, which I filed, was in 2010. And it was based on the e-justice system, the entire justice system that could be converted into I call it artificial intellect. I still do not wish to call it artificial intelligence, because intelligence is something way beyond. I don't think even a human mind is able to replicate the to replicate intelligence. We have intellect, and somehow, therefore, at some point of time when it was named, I think it should have been named artificial intellect rather than artificial intelligence, but that's a different story. Now, I'm here to what I wanted to spread this message was that why should there be a policy? The topic of this panel was why that there should be some governing policies. Why should there be a policy, a government policy determining or controlling artificial intelligence? For this, I would like to share the words of Geoffrey Hinton. If those of you, many of you may be aware of it, but Geoffrey Hinton is really considered as the godfather of AI, artificial intellect or artificial intelligence. In his words, there is a 20% probability that in the next 20 years, AI will take over the activities, almost all activities of the human mind, the human intellect. And there is therefore a need for regulation. There is a need that we need to regulate. There may be policies, there should be policies, not just like Dinesh mentioned about the executive summary that has come, that was issued in 2023 by the Biden administration, the EO. Those are guidelines for patenting subject matter in relation to AI. I believe that the patent system in India is fairly robust. I can say that in the last, let us say, the last two years, almost every AI-related patent, whether it is machine learning, whether it is an LLM, whether it is based on telecommunications, which we filed, our office filed, I filed, has moved through the process very successfully. So there is absolutely, I don't think that there is any issue about getting the patents. Of course, there is an issue of getting these patents quickly. And last year, in fact, there were some patent applications in the field in the domain of AI, where they were granted in a period of about 7 to 8 months, 9 months. The fastest patent application that we got granted last year was about 9 months in relation to where AI was one of the elements of those patent applications of the invention. Now, having said that, the whole issue of whether, in my mind at least, it is very clear that the person who creates the prompts, and that is how it happened in China. There is now a case filed at the Delhi High Court on whether a news media which collects a lot of information from different sources, whether that should be considered as violating copyright. So that is there, and let's see how that develops. Okay, right, Heinz? I can share it to.
Yeah, thank you so much. And I think we spent the second last 3 minutes or so to my dear friend Prabhu, and I must say something. First of all, 52 years ago, I also became admitted as a patent attorney, exactly 52 years, 1972. Second, Professor Ganguly is the first Indian I ever met on an intellectual basis or so, because we were both at the University of Mainz in Germany, not knowing how to spell the word patent, I think, at that time. And he was in chemistry, organic chemistry institute, and I was in the polymer physics department. And so we know each other vaguely or a little bit from there. Then later on, we cooperated in many other fields. Please, go ahead.
I'll just use it.
Okay, okay.
Can you put up the presentation? Oh, you have it? Oh, good. I want to take this particular discussion a bit in a different direction. First of all, when we're talking about AI today, right, we're talking about a large number of technologies getting integrated together. So AI is not just one item. There are many, many items into it. And therefore, I've just taken this slide from the JPO presentation, where you find there are core technologies, very core, fundamental, and there are other things that go around it. And therefore, if you create something like a Venn diagram, there are sort of linkages, and you need to address these linkages very carefully. So that's point number one. Go to the next slide. Quickly, go to the next slide. Oh, yeah? Okay. Now, I wanted to show you this from the USPTO. They had put it up, and they showed the number of, patents that have been granted all the way from something like 2014 to 2023. Going further, you can see what has happened across the world. China appears to be towering high. Then comes USA, WIPO, the PCT applications. India is very small compared to many of these countries in IP-related, AI-related applications out there. Very important is, so this is the same thing there, but important is which are those fields that are linked with AI that are really getting the attention of patents. And you will find software code, molecules, genes, 3D imaging models, speech, other modes, text, etc., are the different areas of technologies which are now, attracting attention of inventors and attracting attention in various patent offices around the world. So therefore, the fields of interest are machine learning, natural language processing, computer vision, predictive analysis, very important. Neural network architectures, AI hardware, and AI-enabled cybersecurity, etc. So it's a huge number of areas that we're looking at. Keeping this in mind, we need to now look at where do we stand in terms of policies and what are the issues. And the issues, if I take, the first part is patentability benchmarks. So if you take some of the recent cases in the EPO, right, and take the guidelines of computer-related inventions in 3.3.2 and 3.3.1 in the EPO guidelines, if you look at some of those and some of the case laws that have taken place, the issue for the NLM and LLM, etc., the issue of what is a technical effect is a big question mark. Unanswered, kept open, and therefore the predictability that Dinesh talked about in the morning, the predictability is very poor. And so what is an inventive step? Number one, we need to look out, and therefore technical effect, and therefore issues of, in how patent offices will be looking at patents, at inventions related to this. Second part, we seldom talk about something that's happening dramatically because we want interoperability, we want things to go across, we want to share. So therefore standards are becoming very important. Now the moment you talk about standards, you bring the ISO, the ITU, etc., into place. Already there are standards being laid out. I predict that in the next 2 years, there'll be a large number of patents that will be slipping into these standards. And we are now entering the era of very soon of standard essential patents in the area of AI. The question is, have we asked these questions? Where are we going? And in terms of policy, we need to address some of these issues. So standard essential patents now are going to become sort of a thing of the future or the immediate future. We need to address that issue. And of course, one of my very favorite topics of ownership of AI and the whole idea, which as you understand now, that it's not just AI, but AI and human interface. There'll be a large number of creations. I didn't just call inventions, because copyright comes in as well. There'll be a large number of creations which will come in terms of only AI-human interactions, and therefore ownership, and therefore licensing, and all those issues are going to be important. Thank you very much.
Yeah, thank you so much, Prabhu. I would like now to conclude that, put now a different hat on. I would like to report what the current questions, the major ones we are discussing in Europe, including Germany at the moment are. First of all, the German Supreme Court has in June of this year decided that AI can never be an inventor. It is a tool, and a tool cannot invent. It is used by somebody who puts it onto a certain task, and that reminds me of the time when I became a patent attorney. That's long, long time ago, 52 years, we saw it just here. And at that time, we always have learned that a patentable invention consists of two parts, namely the problem and the solution. You have to put both, and both of them together makes the invention. So we have AI not as an inventor. Darbus case in Germany clearly decided, and I must cite, however, we had a nice presentation by Dr. Bacher in Taipei, actually, that little, in geography, small part of Greater China, but I would say intellectually giant part of technology deliverer into China, in Taipei in September of last year, where he said, very clear, AI cannot be an inventor, but I don't understand one thing, and this is for our US colleagues, maybe a question. He said, US gave a guidance last year or early this year where they said, AI cannot be an inventor, but it can be a co-inventor together with a natural person. And he said, this goes beyond my mental capacity and intellectual capacity. If you can't be an inventor, then you can't also be a co-inventor. So I would recommend to our US friends, in a very friendly manner, he said that, he is the chair, the chief judge of the Patent Senate of the German Supreme Court. He said they should possibly revisit that. This is somehow intellectually difficult to understand this. That was this one. So that is clear. I'm very happy, by the way, patentability, eligibility. Judge Klaus Krabinski, who is German, of course, he is was a member of the 10th Senate, the Patent Senate of the Supreme Court, who is now the chief judge of the appeal instance of the Unified Patent Court in Europe. And he said in IP Forum last year in April, that question is settled. It is a computer implemented inventions, patentable, no doubt about that. And I'm happy still that India, more or less, they did not adopt it, but they followed the recommendations, the discussions with the European Patent Office and the, at that time, authorities in Europe to have what you call CRI, computer-related inventions. The question is, from my perspective, also settled here. A big question which is not settled is how much you should control. We did not touch upon here this question at all until now. We have to give this morning in our session here to give a general overview of the challenges, the chances, what we should do in artificial intelligence questions with intellectual property in all aspects. And to this afternoon we have two sessions. I would like to invite, certainly with the approval of Danpat Agarwal, that you join these sessions also. One has to do with generative AI, the other one with the regulatory mechanisms necessary. And now finalizing my report from Germany and Europe, we have since August 1st, I think last year, we have a EU AI Data Act in Europe, which is binding in all European countries and which practically prescribes that you cannot do everything with high risk potential AI where you collect data. You must be very careful what you can do, what you cannot do. We have an AI office where you have to put, even if you intend now as a company here in India, a software creator or whatsoever, you intend to bring some large language model whatsoever into the European Union from 26 onwards, you need to give to the Commission, to the AI offices, which are one on the EU level, another one in each of the member countries. You have to give all data there which they need to understand in a sandbox period, where first you have to exercise your new AI-related data collection method, etc. All your data, and now we come to a problem, and I will immediately finish with this because that needs a full session. Maybe we can do this in the afternoon here. The problem is now raw data, at least in Europe, are not protected. They are not by copyright protected. You need to structure them. Somehow you get copyright then protection. You can also, under certain circumstances, patent this method to collect and to use, etc. But they are not protected. So don't we need, before we give to the Commission, to these AI offices, all the data we collect, possibly by face recognition, by publicly make available security concerns with certain assemblies and associations or so, do we not need to find a mechanism how to protect this? And that is, again, subject to another session we have tomorrow. I'm immediately finished, and I know, and we will then tomorrow have to see what we can do to protect data as such. We need probably something like a trusted depository. That's a different question. That's all. Now I come back to my announcement earlier. What should happen with inventions? And it's a question now to the whole audience. Which inventions which are made by a system that uses AI to create something. Let's, for example, look at what is actually being done already today. If you have a turbine blade of a jet engine, it looks like a knife, and you measure the temperature from the axis to the outer periphery. These data are daily collected by thousands of flights and 10,000s in the world, by General Electric, by MTU, by whomsoever. And now you can make new turbine blades out of this. You put this into a 3D printer with a suitable algorithm, and that will make sure that the best turbine blade is not like a knife. It is very thin, where there are only low temperature and stresses. There is very thick and stable, where you need more material to be stable enough and temperature resistant. And you get, when you look at it, at the product, it is new, it is inventive. You never saw something like that. It uses less material, it's better duration, etc. Now the question is, if you make such a thing, which is certainly a patentable method, no doubt, and the person who becomes the inventor of this new turbine blade is certainly the one who put this AI system somehow onto the task. Here are the jet engines, you measure all these things, and now you have some new construction with less material and higher temperature resistance or whatsoever. And now the question is, should not, if you use such a method, like a method of manufacturing a pharmaceutical by temperature and pressure and something good comes out at the end of the day, should the product not possibly also be protected then? The direct product by such a method, the characteristic part of it is that an AI system is used. I don't know. We have no provision for that. We have all over the world, I think also in India, of course, United States certainly, Europe certainly, you have this, that the direct results of applying a certain method, which is patented, that they are also protected as a product. Now, question, should that be the case also if you use a certain device, a certain computer-related system to create something, that the products are also protected? We are in the old Brevinville, for example, remember this old problem of if you have research tools, a matrix system to check 10,000 substances, are they suitable for some clinical application or something? Should the product coming out, which is unpredictable before you use the whole method, should it be protected or not? At that time, the EPO at least decided, no, not protectable, no reach-through claims, as we call it. How should it be if you use AI? Starting with you.
The problem is not really about the protection, because as far as the question of protection is concerned, you follow the basic norms of the patent law and see whether it's an invention, whether it's patentable. The bigger problem is who is the inventor and who is the owner. The ownership and inventorship. So regardless of from which angle you look at the AI-related invention, you come back to the same point, whether an AI can be an inventor. If I create an AI which is capable of doing a lot of things, I am the inventor of that AI, and I'm sure I can patent that AI in my name. But when AI starts doing things on its own and creates without my human intervention, then the problem arises, am I the inventor? It's no more, in my opinion, I am no more an inventor of an invention if it was created by my son, where I had absolutely no role in it. I created my son, my son creates an invention. I'm not an inventor. So I think the logic comes, I think the same logic applies here.
But we didn't see an AI system yet which marches through this room and starts to find a task to be solved and solves it. We didn't find this yet. There's a human being directing it.
So I would agree with him, I would say that yes, the product would be certainly patentable, but how do you disclose it? How do you disclose the process? So that will be the problem. And that comes like how, because now your AI machine learning tool is a black box for the inventor. The inventor can give in the problem statement and knows the output, but what happens inside, how do you disclose it? So without that disclosure or enablement, you'll never get a patent. So products, yes, but method of manufacturing is very doubtful, and probably we come back to the same question. Especially in India, we have a huge problem of subject matter eligibility, So we still have those 2017 CRI guidelines. There is no guidance on AI or AI-related inventions or any new tech invention. So that certainly we need from the IPO. So how do we disclose this? What are the enablement requirements? How do we deal with these kind of invention? That is a question which will have to come up, because recently we have seen even in the courts, when you actually go and enforce these patents, both in OpenTV and BlackBerry, the courts have rejected algorithms, these applications, because they were considered to be algorithms, Again, in the famous Ericsson case, out of the 8 patents that were enforced, 1 was revoked because it was considered to be a algorithm. So we need to nail this problem first, before we actually get into more deeper that how in India we need to nail the subject matter eligibility, disclosure, and enablement requirements. And the answer to your question is yes, it would be patentable, but how do you disclose it? Thank you.
I like this answer a lot, how to disclose. We have to find mechanisms how to disclose this. Prabhu, what is your opinion? Should the product be protected by this method of using a certain AI to produce something, the product?
I think the product can be protected, is patentable, certainly. I think we have to now really ask the question as to, which I've always asked, whether the AI, can we, from a judicial standpoint, from standpoint of law, can we then assign some sort of a legal personhood? Unless we look at that, I don't think we'll be able to answer the other questions.
The issue arises that most of our patent laws, they speak of all the patent laws, in fact, in the world. They say that they have defined a person to be a natural person. And that is where, I mean, it was never conceived when the lawmakers wrote the law. That's why there is this policy requirement. When they wrote the law, they did not conceive of the fact that there could have been an artificial person. I'm not just speaking of an artificial intelligence. There could have been an artificial person. Now, the whole issue also that has to be decided are twofold. There is a person who created, in Heinz's case, there's Heinz, that the person who created the AI, that is one. And there's the person who uses the AI, that is the other. Now, which of them, between them, is the person who created the AI? Should he be considered as the inventor because he provided the tool? Or should the person who use the prompts, you know, there are the usual prompts that are there for generating certain data, certain learning. That is going to be the issue, and that is where the policies must lay down this. This is where we need to have policies.
Yeah, first of all, thank you so much. Now we have been asked by the organizers, we have been asked to give the audience a chance to ask questions. No time, obviously. I raise one question still in a minute. And also I would like to declare, and I think I speak for all of the speakers here, if you have any questions, comments, whatever, in relation to what we have tried to explain a little bit in the last 45 minutes actually, please send us emails. We are all happy not to consider this as a professional duty or no, as a professional work which we would charge to anybody. Is questions of a general nature we could not clarify here. It is our fault, particularly my fault as the moderator, and please ask and let's keep in dialogue also in future. Now the question comes, who is of the opinion that an artificial intelligence, AI, can be an inventor? Raise your hand, please. There is one person, I see a very prominent promoter of the patent system in India. Pravin has raised his hand. Pravin, I think you are the only one. I'm really sorry about this, but very brave. Now, who is of the opinion that AI can only be a tool in the hands of somebody who uses it? This is the overwhelming majority, at least it's more than one voice, would be 30 or so, and the last one who is uncertain. It could be that way or that way. I would assume the rest one who didn't raise any hand. Thank you very much. Ask your questions later on in email. I hope I did still halfway keep our time here, and it was a great discussion. Thank you.
Thank you to our esteemed panelists for their valuable insights on AI, inventions, and inventors. Now I'd like to request Professor Dr. Heinz Goddaer to individually felicitate our speakers. First up, Mr. Hari Subramaniam, founder of Subramaniam and Associates.
It says Certificate of Excellence presented to Mr. Hari Subramanian for delivering an insightful session during the 17th annual edition of Global Intellectual Property Convention at the Leela, Mumbai on 11th and 12th of January 2025, and it is by Dr. Dhanpat Agarwal. Thank you so much. And I don't read the other ones because except the name, it will just be the same.
Next up, Dr. Mohan Diwan of RK Diwan and Company. Next, Dr. Prabuddha Ganguly, CEO of Vision IPR. And now, Dr. Anju Khanna from Lal and Sethi. Now I'd like to call upon Dr. Dhanpat Ram Agarwal to felicitate Professor Dr. Heinz Goddaer.